A string of bombings. Police say the attacks happened
security.
in several
Violence
cities,
broke out
including
between
Baghdad.
some of the inmates and the guards.
It is not the breaking of a man's doors and the rummaging of his drawers that constitutes the essence of the offense, but it is the invasion of his indefeasible right of personal security, personal liberty, and private property, where that right has never been forfeited by his conviction of some public offense. Justice Joseph P. Bradley. Recently, the U.S. Supreme Court overturned a Maryland court's decision which paves the way for states to collect DNA from people who have been arrested. So before we talk about that case, let's talk about some basics of DNA. Currently, all 50 states and the federal government collect DNA from people who have been convicted of a felony. So these are criminals. That DNA is collected and it's entered into a national database. Now there's 27 states that have laws on the book which allow for some type of collection of DNA from people who have been arrested. Now there's a wide degree of collection in there. Some states collect DNA on every single arrest. Some states only collect DNA on very serious crimes. Supreme Court's decision basically overturned the Maryland court. Maryland court said it was unconstitutional to collect the DNA from this suspect. Now, the U.S. Supreme Court overturned that and based most of their decision on DNA collection is no different than fingerprints. So we're using DNA to identify the person, just like we're using fingerprints to identify the person, and like photographs. But when I look at this case and I read Justice Scalia's dissent, it's pretty clear to me that in this specific case, which is what they're ruling on this specific case, DNA was not used to identify the suspect. The suspect was arraigned 3 days after arrest. His DNA wasn't submitted for testing until after the arraignment. Reason being, that's Maryland law. So you can collect the DNA at time of arrest, but it cannot be submitted for testing till after arraignment. They already had his identity at time of arraignment. Now, that DNA wasn't actually tested and uploaded to the database system for 3 months later. So the argument that DNA in this particular case was used to identify the suspect is kind of crazy, because it wasn't. What's fascinating here is Maryland's DNA collection law gives very specific reasons why you would collect DNA from an arrestee. And get this, one of those reasons is not to identify a suspect. Now it is to solve unresolved crimes, which when you hear that, it sounds good, right? It seems like a noble cause. Let's remember something. This person is arrested. They have not been convicted of a crime. Okay? They are innocent until proven guilty. Last time I checked, that's still valid in the United States of America. We're talking about taking someone's DNA here, and we're talking about running it through a database. Now, I believe this to be a violation of the Fourth Amendment. Now, let me explain. So we have someone who's arrested here for a very specific crime. Now, we had probable cause to arrest them. Now, we are going to ID them, probably take their fingerprints and say we've figured out their ID. If they have a prior record, we've pulled it up. But now we're going to take their DNA. And we are going to take this DNA and we are going to run it in a database over here of unresolved crimes, or DNA that's been collected from crime scenes. Now, we have no reason to believe, none, that this person is involved in any other crime. We don't suspect this person of anything else, but we're going to run their DNA in this database over here. That is a clear violation of the Fourth Amendment. That is a suspicionless search. That is the same as a law enforcement officer stopping by your house that doesn't suspect you of anything, but knocking on your door and saying, I need to come inside to just make sure you're not doing anything wrong. But all of a sudden, we add science to it, and we say it's okay, but it's really no different. Now, there'll be some people that are going to say, you know, if you're not doing anything wrong, what does it matter? Just let them take your DNA, and obviously you're innocent, so it's going to come back, and you'll be let go. I can't stand those arguments, because would you be happy with me just bringing 20,000 people along and having us go through your house and look through your medicine cabinets and posting your financials online for the world to see? Wanting to catch bad guys is a noble cause, but not at the cost of us sacrificing our constitutional rights. We can't do it. There's ways to do this without violating the Fourth Amendment. A lot of times, laws that are passed like this have victims' names attached to it, and they're very emotional. It's very hard. But we cannot allow emotion into these decisions. I don't doubt that this possibly could catch some people. But at the cost of us violating our constitutional rights, I can't go along with it. I can't agree with it. But we bring emotion into these, and we don't look at the unintended consequences of possibly building a DNA database of innocent people. And the argument is always made, well, this is for a better society. You need to do this for a better society. I don't agree with that. The best society is preserving our rights, our individual rights. Not removing a check and balance in the system here and allowing our Fourth Amendment rights to be violated. And that's exactly what I believe the U.S. Supreme Court has done in this ruling.